the bags. Let me go check.
Learning.
Well, we're just getting organized. I want to thank everybody for coming here. We're here to discuss my new book, which I co-authored with Brandon P. Denning of the Cumberland School of Law. The book, I think, is a timely one, to trust the people with arms, the Supreme Court, and the Second Amendment. And in it, what we try and do is to look at the evolution of the concept of the right to bear arms, why it lay dormant for so long in American jurisprudence, at least federal jurisprudence, I should say, and then how indeed it comes to life, the Second Amendment, in the United States Supreme Court in the 21st century, and the challenges of crafting the jurisprudence of the right to bear arms in the 21st century, when in some ways it had laid dormant, or as we say in the book, in some ways it had missed the constitutional bus, or a number of constitutional buses that drove by in the 21st century. So we found it exciting to work on, and I can probably say with confidence that we're probably, Brandon and I are probably the only two people in the legal academy who have cited field manuals for the maximum effective range of various rifles that were used by the Army during the 20th century. Not usual citation for in the legal academy. Also, just as a matter of self-interest, we're selling copies of the book. It will be $40 a copy, which is $10 less than it is on Amazon. So with that, I would like to introduce our two commentators, Professor Joyce Lee Malcolm, who was a major influence in the scholarship on the right to bear arms, particularly with her book, To Keep and Bear Arms, looking at the English roots of the right to bear arms and its influence on American legal thought in the area. And Professor Renee Lerner, who is an expert, among other things, on the jury and on English legal history, on which so much of American legal history depends. So without any further ado, let me turn this over to Professor Malcolm and then Professor Lerner.
Hello. Are these on?
Are these? Yeah, I think they are. Testing.
Testing? Hot mic?
Testing.
No.
Oh,
I think.
Give it
Oh,
to
it
us,
is.
Rick.
It's on. Okay. Thank you all for coming.
No, I think it was on before.
It was on.
And now I've turned it off?
Yeah, I think so.
I'm an historian and not. Okay, so there we go. Okay. It's a pleasure. I was just telling Professor Cottrell that the first time I met him was at the beginning of a very long, battle seems a little harsh, but campaign when the Second Amendment was very much passed by many buses. And I was asked to give a comment on the paper at law school piece that he and Professor Diamond had written early in their careers. And I was at the Radcliffe Institute working on the origins of the right to be armed. So they asked me to come and comment on their work. I don't think there was anybody else probably around in those days. Anyway, we've known each other and have sat together on many a panel and been attacked by many of those who really disagreed with us vehemently ever since. So it's finally at the stage where I'd like to think that the fat lady has sung. We have three great Supreme Court opinions now, but I'm not really sure that the end is in sight. I should say I'm very glad that this book was halted until the Bruen case was decided, because that makes such a difference. But whenever you do a work that goes up to modern times, there's always this chance that lots of other things are going to happen. And so you're not really always going to be up to date. But just commenting on the book, I think it does a wonderful job of surveying the early British history, colonial era, the drafting of the Second Amendment, and also the history of the militia and its change over time from being the necessary security of a free state to being just a branch of the military, which kind of defeats the whole idea that it was, an independent citizen organization. We now have the unorganized militia, which we're all a part. Apparently, some states even have uniforms for us.
I think they do, yes.
Yeah, we should appear in our uniforms. But at any rate, the book is a wonderful in going into all of this. It covers this period where there was a great deal of effort to keep people who were not felt to be reliable from getting weapons. The African Americans in the South, people coming in as immigrants from Eastern Europe in the North, and some of these laws, like the Sullivan Act in New York, were in place for a very, very long time afterwards. And I think it's important to focus, like these authors did, on the impact on minorities and how different it makes if they can be disarmed by the government. So this was a really useful thing to include. I also cover some of the different theories to basically, this was during the 70s and 80s, erase the plain language of the amendment. It always seemed to me very much easier to try and misinterpret something out of existence than to try to remove it or alter it in some way. And there were a whole series of different meanings. The collective right, where there was no individual right meant. It only protected the state's right to have a militia. There was one theory that I particularly liked called the comma theory. And because there were sometimes three commas in the right to bear arms, the militia, and then comma, the right of the people, comma, to keep and bear arms. That anything between the commas could be eliminated, and therefore there was no right. The people were completely taken out of that context. There was also the bogus theory that it was all meant to be about slavery and to preserve slavery. And I'm glad it has that label because it is a bogus theory. And at the end of this period of much discussion about what it meant, as an example for you, in 1975, the American Bar Association appointed a special committee to figure out what the meaning of the Second Amendment was. And this special committee, looking at all the different ideas, came up with the idea that the founders and drafters had no intention in mind at all with this amendment. I thought, throw up your hands and say it meant nothing. They just needed something between the First Amendment, the Third Amendment. Just showed the state that things were in. But at any rate, since then, there was the Heller opinion in DC versus Heller, I should say, which really was tremendously helpful in 2008. And then later, the McDonald versus the city of Chicago, which had almost the identical law prohibiting people from being able to have weapons. And now, last year, the Bruen case of finally getting back to New York and trying to sort them out. I should say, I don't want to take too much time here, but I should say that the one thing, there are a couple of things. First, it's kind of dismaying that immediately after one of these opinions, Washington, D.C. had a law that it was immediately going to put into effect, which basically would do the same thing. Okay, you have a right to have arms, but you have to go to the police station 4 times, you have to have fingerprints, you have to do this, you have to do that, it's going to cost you a lot. You have to keep reinstating and renewing your application. If you fail to do that, you can go to jail and pay a fine of $1,000. So they were all set to make it a non-entity. Chicago did the same thing. And New York State, after Bruen, has done something quite similar, actually enacting all kinds of things like that you weren't allowed to have weapons in a place of religious observation, it's called. And they could look at your social media sites for the last 2 years to make sure you were an appropriate person, and a whole series of things. And each time, because of the way our system works, we have to go back to the courts and try to sort out these ideas which are so, are meant to really get around the Supreme Court's opinion. So it's sort of depressing. And as an example of how the fat lady, according to our opponents, hasn't sung yet, the Wall Street Journal, I don't know if you saw this, yeah, over the weekend published, the justices are bad gun historians. Now, everybody sitting on this panel is a historian, right? But we don't count. It's the Supreme Court justices made a big mistake in those 3 opinions. These, according to them, they never give up. So, if only they would announce that, as you would say at the end, let's agree that it exists and work on what makes sensible law for the way that it ought to be enforced, rather than insisting that the Supreme Court justices made a bad mistake. I'd just like to close by 2 things that I think are, that I really admire in this book. Apart from the fact that you really feel almost like you're sitting in the courtroom when they go through the appellate arguments before the court, you know, the back and forth questioning, which is very lively. But the end of it, the introduction, the authors say that they talked about having contributed to a lot of Second Amendment briefs pro bono. And then they write, "We did so because of our concern for fidelity to the constitutional and historical record. We did so because of our belief that the debate over the Second Amendment is a debate over the most fundamental rights, the rights of ordinary people to defend their lives. In this discussion, we won't claim to be neutral commentators. Few scholars approach this issue, or indeed other issues involving modern history, without prior opinions. Nonetheless, if we cannot be neutral commentators, we will strive to be fair ones." And I think that's all you can ask, really, to try and be fair, to present the evidence as it is on both sides, and come up with your own conclusions. I think they also admit that the fat lady may have sung as far as Supreme Court goes, but there are still all of these efforts to work around it, which means we need to be in it for an even longer run. But thank you all for coming. Looking forward to any questions.
Thank you.
Well, congratulations to Professor Cottrell and Professor Denning for writing such a monumental account of the Second Amendment.
Right.
And this is now the new standard in the field. This is the definitive account. And it is an especial honor to be here with Joyce Malcolm. Joyce Malcolm, who herself was one of the pioneers in this field, working on the study of the right to bear arms in England. And she takes her place in the history of this field. She is discussed in Bob's book, as she ought to be. So it's an honor to be here with both of them. This book, as I say, is monumental, but it's also readable.
Yes.
It is, the text is 293 pages, which is fairly concise given the sweep of it. And it's a page turner. It is not written in academic jargon. Bob makes it a point in all of his books, and they're all beautifully written, to write in English, which is a great relief to many of us that have to wade through this academic jargon. So thank you, Bob.
Thank you.
And I say, it really is a gripping account. It weaves together several different things, not just the US Supreme Court's doctrinal theories, which, given the title, the Supreme Court and the Second Amendment, of course, that is the main point of the book, but it also weaves in a lot of other things. Social and political history, and the changing technology of firearms. And all of that helps to illuminate what the courts have been doing and popular movements have been doing in this area. And I have to say, on the technology of firearms, I learned a lot in this book. I was fascinated in particular to read about the development of the Thompson rifle, which is maybe better known as the Tommy gun. It was a selective fire submachine gun. invented at the end of World War I, actually, but so late in the war that it never actually made it into the hands of American troops in that conflict. But it became widespread among civilians after that, and known to us primarily during World War II, as I believe it basically became the M1. Or close. No, it did not. Okay.
Well,
Bob needs to clarify this.
the Thompson submachine gun was adopted by the Army in 1928, and the first iteration, military iteration, was the M1928 submachine gun. Later in World War I, they did call one version of the Thompson, the M1 Thompson. But typically, the term M1 is used for the M1 rifle or the M1 carbine, which are
Okay.
different.
Well, thank goodness Bob is here to clarify. But in any event, the development was really fascinating. And of course, makes a lot of difference in terms of popular attitudes, the technology of firearms, in terms of popular attitudes and also the opinions of the courts. I'd like to highlight a few themes that run through the book. And some of these Joyce has already touched on. And those include the militia, slavery, race, and ethnicity, and empirical studies. So on the militia, I think Bob definitively shows that this was a very broad concept in the mind of the American founders. Essentially, all able-bodied men were in the militia. And the Second Amendment's right to keep and bear arms, therefore, when it refers to the people, it basically refers to a large group of people, indicating that it is an individual right. And Joyce's work supports that conclusion. And the militia was not only a broad concept, but an important concept throughout American history. In American popular culture, ordinary citizens have a special role to play in the defense of the community. And this idea is closely tied to democracy. A passive citizenry that is helplessly waiting for the police to arrive stifles the active spirit that's necessary for self-governance. An excellent example of this way of thinking appears in an opinion by one of my favorite judges. And Bob, I don't know if you know that he's one of my favorites, but Joseph Lumpkin of Georgia, the Georgia Supreme Court. In 1846, he wrote this, and it's quoted by Bob. The right of the whole people, old and young, men, women, and boys, and not militia only, to keep and bear arms of every description, and not such merely as are used by the militia, shall not be infringed, curtailed, or broken in upon in the smallest degree. And all this for the important end to be obtained, the rearing up and qualifying a well-regulated militia, so vitally necessary to the security of a free state. So that was Joseph Lumpkin in 1846. And he, by the way, was a Unionist during the Civil War. So he was not a sort of lawless Johnny Reb. The idea of a militia compromising basically the whole people remained current among elites even until the early 1960s. And after World War II, to kind of give you a sense of this, there was a large surplus of weapons, military weapons. And the US government sold thousands of M1 rifles to civilians with no criticism at the time. Actually, Bob, how many would you estimate?
Well, I'm thinking you have to combine two things, the M1 rifle, the Garand, and the M1 carbine. And between them, I would estimate at least 3 million were basically sold to the public. By the way, the M1 carbine, which is mid-1940s technology, you hear all the debate about the AR-15 and this is something new and high-tech weaponry and whatnot. I would argue that the AR-15 is basically a gloss on the M1 carbine. That is a semi-automatic rifle, low-powered rifle with a detachable box magazine. The US government sold those by the millions to the public in the 40s, 50s, and 60s.
It's
Wasn't there an issue that they didn't want them to go into unsafe hands?
Well, yes, the idea was, we'll sell surplus weapons from the US inventory and also from foreign inventories to American shooters rather than have them go into the hands of revolutionaries around the world. So
Yeah.
it was a deliberate government policy in the post-war era.
Yep. Something for us to very much keep in mind. In 1961, in fact, the US Army, as Bob points out, had a Directorate of Civilian Marksmanship. So as late as 1961. The story, and Joyce picked up on this, the story of race and later ethnicity and firearms in the US is central and fascinating. Bob shows how laws in the 18th century about possession and use of firearms by Black people were relatively lenient compared with what they became later. And after the slave revolts led by Denmark Vesey in South Carolina and Nat Turner in Virginia, the laws became much more restrictive and amounted to basically prohibition on Black people owning firearms in certain states at least. And Bob explains how the Civil Rights Act of 1866 had as a principal goal the arming of Black citizens for self-defense in the face of Southern state prohibitions. Of course, these were not prohibitions on white people, these were prohibitions on Black people. And he shows the importance of that act in interpreting the 14th Amendment. A century later, the civil rights movement claimed to be nonviolent, and it was. But, as Bob shows, it depended crucially on armed protection by Black self-defense groups. And Bob describes the Deacons for Defense and Justice, which were essential to the civil rights movement. So it's important to keep that in mind. And it was a nonviolent movement, but it depended on people who owned firearms being willing to protect them. And as I say, race is a major theme of the book, but Bob also shows how ethnicity played a role as well. In the early 20th century, many natives were concerned about the effects of immigration from Southern Europe in particular. And they feared the spread of the Black Hand and other Italian-American organizations as America was rapidly urbanizing. And it's hard for us to get a sense today of just how fast that urbanization occurred. The cities were growing spectacularly during the early 20th century. And in some cases, had more people then than they do today. So quite remarkable. And these sorts of anxieties about Southern Europeans, about the growth of cities, were a primary motivation behind New York's Sullivan Law of 1911, which Joyce referred to. This was by far the most restrictive gun measure to date. It required a license to own or purchase pistols. So another fascinating strand in this book is empirical work. And Bob traces its evolution from the 1960s and 1970s. That was sort of the first wave of the gun prohibition movement. And Bob's familiarity with the sociological literature helps him to see where some of those studies went awry. The gun prohibition had many successes during that period in banning certain guns, and in particular handguns. But among its successes was not crime reduction. Crime continued to soar during that period. And Bob shows how empiricists such as Wright, Rossi, and Daly in one set of studies, and later Gary Kleck and John Lott showed how the importance of self-defense with firearms had major deterrent effects on crime. According to one study, 64% of felons surveyed said that one reason burglars avoided entering houses when people were home was a fear of being shot. I also commend to your attention Bob's masterly description of academic trends in interpretation of the Second Amendment. And the sort of arc of academic interpretations is a fascinating one. It began basically with a widespread understanding before the 1960s that the Second Amendment protected an individual right. But then it evolved to a collective defense theory in the 1960s and 70s. under which the Second Amendment merely protected state militias from federal interference. That was the official interpretation of it among academics. And people like Joyce took a hard look at that and began to dissolve that understanding and to reassert the importance of the Second Amendment as an individual right. And she began her research in the 1970s.
Back in the day.
Yeah, a while
And it was
ago.
very unpopular for people used to say, how did a nice girl like you get involved in a subject like this? It is not thought to be that way anymore.
And then she and others' work got traction. And in the 1980s in particular, and here is, I just have to read you this. This is such a classic. This is an example of Bob's writing and the feeling among constitutional scholars in the 1980s. And here's what he says. The Second Amendment was one great area of the Constitution and the rights of the American people that remained largely unexplored. So Joyce and others were beginning to explore it. For scholars who felt that they had written their umpteenth article on the First Amendment and the freedom of the press, or the 14th Amendment and equal protection, here was new territory, an exciting prospect. And since then, scholarship in this area has taken off, and it has become now a mainstream idea that the Second Amendment protects an individual right. So what was once radical has now become mainstream. And that academic foundation was crucial to the decisions in Heller, McDonald, and Bruen, which the book describes so thoroughly. It's really a mesmerizing account of the origins of this litigation and how they progressed, and even to the courtroom. So all of that is such an immense contribution to the field. And I urge you to buy and read this fascinating and indeed gripping book right over there about the right that protects all other rights.
Thank you. Any thoughts or questions? People might want to. Yes.
First of all, Bob, congratulations.
Thank you.
It's amazing to have a book like this. It's a tremendous resource. And I wanted to ask you a few questions. I don't mean to interview you. I'm just very curious, right? One of them is, why do you think a book like this was needed right now? Why do you think it was important to write it at the moment? You know, and if you could talk to us a little bit about your process in writing a book like this, especially on an amendment that has so much history. We have a lot of students in the room, and I think they're very curious to hear a little bit what your process is, you know, what you think is important to know right now about the Second Amendment.
Well, I think there's several things. A lot of people in looking at Heller and the subsequent cases seem to think that it came out of nowhere. You know, that the Supreme Court was on a frolic one day and suddenly discovered the Second Amendment. Nothing, in fact, could be further from the truth, that it's as old, indeed older, than the Republic, if we go back to the English origins. But there were a number of reasons why it lay dormant as a matter of active jurisprudence. One involves the whole issue of incorporation, the application of the Bill of Rights to the states. Most gun control legislation has been state legislation, and it was essentially not reviewed because the Supreme Court went about the business of incorporation in a kind of roundabout, circular, and in my way of thinking, not very precise or direct way. So we missed incorporation, which would have been the application of all of the Bill of Rights to the states. And we instead developed it by a roundabout process, and the Second Amendment was bypassed by that process. And so people sort of assumed, well, it wasn't an individual right, and that the court was somehow saying it. Actually, the court never said that. The court simply said, followed 19th century precedent that said that the Bill of Rights didn't apply to the states, even though they reversed that precedent with respect to the other rights. They didn't get around to it till the Second Amendment, really until 2010. So that's I think one important way of looking at it. Why, we looked at the book in part because the question, why so late? Why is it that it was so not understood for such a long period of time? And I think one of the things we do is we go into that and the relationship between the 14th Amendment and the court's jurisprudence of the 14th Amendment and what actually or ultimately happened with respect to the second. Yes.
It was briefly passed over in the beginning of the remarks, but I'm kind of struck by the, I'm not sure exactly how to say it, but so like in the origin of the Republic, you would call up the militia, and in the modern era, you would call up the National Guard. And in what way are these like not meant to be the same thing, and that everyone is now a militia and they're not a part of a militia, or you're not allowed to well regulate them? So I'm just like, the wording is like kind of, that does feel new.
Well, I would argue
The
that
modern era.
the National Guard is really sort of a condominium between the militia and the Army, and now the Air Force, which is, the National Guard was actually reorganized in the 1920s to be a reserve of the Army, as opposed to simply the state militia. And yes, it still has connections to being the state militia. But in fact, if you join the National Guard, you're joining the Army or the Air Force. And the first thing you do, you will go to basic training at an Army post or an Air Force base, and then subsequent training at one of those things. The militia, the idea of the militia as a whole, though, I would argue still exists in the 20th century. One example that we cite is Dunkirk. The British Army is trapped in France. And the British government says, if you have a boat, please get over here and take people off the beach. You're calling ordinary citizens to do a military function as such. So this concept of the militia as a whole is still, I think, a live one, even though it's perhaps not exercised as much as it might have been in the 18th century.
Can I add something?
Sure.
I think one of the other things about the original idea of the militia, which is a little worrisome just now, is that it was meant to protect the population in case the government became tyrannical, so the people could protect themselves. So once it becomes part of the Army under the government, it can no longer serve that purpose. It just is kind of co-opted by the government.
Yes. Also, one thing I would also say that we should think of in terms of the militia is think of militia as they were conceiving it, perhaps more like a posse than the militia as we're thinking of it in terms of the National Guard. Turn to Turner Classic Movies and watch the old westerns, and you'll get an idea of what I'm talking about.
Even today in some Western states, occasionally the sheriff will call on everyone with a firearm to go out and get somebody, because law enforcement is few and far between out there.
Yes.
It was a lot to ask a panel of historians to forecast, but actually today the Supreme Court is hearing arguments in the Rahimi case dealing with issues about whether or not people with civil protective orders can still have access to firearms.
Yeah.
I'm just kind of curious for your thoughts about how the court might elaborate on this new era they've dipped into with Bruin.
Okay. I think Dean Morrison, were you just at that? And
Yes, Dean Matthew was with me, and I'll let her speak first because she outranks me. But I'm glad to speak with her.
We heard a brilliant argument, and your question is, how do we predict it will come out? I'm predicting 8-1, upholding the constitutionality of the statute from the Fifth Circuit. That's reversing it.
okay.
I concur. There was nobody attacking the Solicitor General during her argument.
It was a beatdown, is what I'm telling you.
Justice Thomas probably will not change his opinion, but everybody is very concerned that his opinion was attempt to put down a test that was much too broad, and that people were construing it maybe not the way he thought it should be construed, but certainly not the way many other members of the court thought.
I wonder if a case might be made that in Bruin, that Justice Thomas staked out a very far out position because he's trying to send a message to the lower courts that he thought weren't applying Heller and McDonald correctly, and that he just simply took it a step further than anybody else is willing to go on that. Or at least this case may have shown that.
And Justice Gorsuch several times said, "Do we have to decide that next case? This one's enough. Let's just decide this one today." So we don't know. The Solicitor General at the end said, "Please get the message out to the lower courts to not do what they've been doing, and they'll do that. But the question is how much they're going to do on that." I would be very surprised if it was other than 8-1. Could even be 9-1.
Heller, by the way, just in jurisprudential terms, Heller is interesting because it in some ways illustrates the difficulty of an originalist jurisprudence. Let's imagine for the moment that you read the history the way Justice Scalia read the history in Heller, and you're writing the opinion. How do you write the opinion? And this is the problem that I think Scalia had. Potentially, the logic of the history as he read it should have included automatic weapons, or at least arguably might have included automatic weapons. And yet, he clearly wanted a decision that did not include automatic weapons as being within constitutional protection. How do you do that? Well, you write, adopt the common use test, which is part of the jurisprudence that we have with Heller. Well, why aren't automatic weapons in common use? Well, they're not in common use simply because the 1934 Firearms Act made them uncommon and also caused the Army, when it did its great sale of World War II weapons after World War II, to not sell automatic weapons to the public, even though everything else was sold to the public. So in some ways, you get a kind of circular reasoning. We're going to have common use or use a common use test, but we're going to use a common use test, and we're able to, the only reason automatic weapons are not in common use is because, in fact, they had been essentially put under very strict restrictions in 1934. Even within an originalist framework, accepting his history, there's still the difficulty of how do you make a workable decision within that framework. I need to be excused for a few minutes, but if you want to go on.
Okay, yeah, just quickly.
Mhm.
Also, Heller pointed out that you were entitled to have weapons that weren't common use for self-defense. And I think it would be a hard call to say that an automatic weapon is useful for self-defense. Just sort of sprays bullets all around.
One thing that we might talk about maybe a little bit later, Alan, is the posture of the case. That it comes because of a civil protective order. And it's interesting, given his history, Rahimi's history, as far as I can tell, that there ought to have been some prosecutions there for violent offenses. And it's interesting that the prosecutors today seem to not be so concerned about some of those things. So sheds a bit of light on the situation of prosecutors in a certain extent in America today.
No, I think what he said was that there are some criminal charges pending against the defendant, state court charges that are being held in abeyance until the federal case gets resolved.
Okay.
So there are some, but I think they're misdemeanors. They're firing off the guns and he didn't actually shoot anyone.
Yeah.
Shot at things.
Right. Certainly, they could be categorized as violent, it seems to me. But
What makes that difficult, these restraining orders, is that in some divorce cases, lawyers for the wife, for instance, might tell her to just go ahead and check the fact that this guy might be dangerous as a way of getting, more advantage over child custody or something like that. So sometimes it's sort of checked when it isn't actually a fact that this, that the man in the the relationship had actually done anything threatening. So it can be a kind of checkoff, unfortunately. I'm just saying this as a hearsay because I understood, particularly in California, that a lot of attorneys will recommend that people do that.
Sorry about that.
She is not recording this. I don't know what just happened, sorry. I would like to respond to that if I may.
Oh, sure.
Um,
This, as I say, it's just
I'm
hearsay.
sorry
But
to be late, so I don't want to disrupt.
Oh, go ahead.
We were just at the Rahimi argument.
Yeah,
Oh, right.
Yeah.
That's kind of a myth. I don't know what's going on in California specifically, but we've been hearing that myth for decades, since the civil protection orders began existing.
Right.
And it's the claim that people who are getting orders issued against them, that, you know, it's just a divorce tactic, it's just a divorce tactic. And a lot of judges adopt that, and Judge Ho adopted that view for sure in his concurrence. But there's really no evidence that that's true. And it's also true that it's not easy to get civil protection orders, that you actually have to prove your case, and a lot of cases get denied. So, you know, the idea that women are willy-nilly making up false claims, there's just nothing to it. It's kind of a common claim when it's a woman-identified crime or problem to suggest that it's being fabricated for some kind of unfair advantage. But just so you know, I'm Joan Meyer. I run the National Family Violence Law Center.
Oh,
here.
okay. Well, obviously, as
Domestic
I say,
violence
this was hearsay from people who claim to
Um,
know. So,
We're not fond of Ho's concurrence in that point of view.
I'm not an expert in this area, and certainly not as you are, but I actually have some personal experience with a woman making a false claim against a man for violence in the context of a divorce, a very dear friend of mine. So I have to say, from personal experience, it does happen. I don't know how common it is, but it does happen. Now, in that case, she got a temporary restraining order, so for 3 weeks. And you know, didn't jump through all the hoops that one would have to go through to get a permanent restraining order. But at least for temporary restraining orders, that can happen.
So those are ex parte, if what you're talking about is a temporary protection order?
Yeah,
So he's not there to deny it.
right.
So it's easier there. But once you
Yeah.
get to the real hearing, he has the chance to. run his
Exactly.
evidence.
Exactly, but I'm just saying, at least for that temporary period.
I stand corrected. It's not that it never happens, it's that it's not common. And the idea that it's the norm is really a major distortion.
Thank you for the discussion. I liked how you mentioned briefly kind of how the jurisprudence of arms rights under the Second Amendment has evolved throughout American history. I just thought of how kind of the status symbol of a firearm has changed from kind of the necessity, a tool of the frontier, to now it's kind of just an accessory. And there obviously are immensely different ways that we view a gun socially now. How do you think that has influenced the evolution of firearms jurisprudence?
Ooh, I'm not sure that it's an accessory. So I have 2 children right now who are at the University of Chicago as undergraduates. The University of Chicago, as you may know, is in Hyde Park. Hyde Park is a dangerous place. It just is. And I know a lot of residents of Hyde Park, want to be armed because, they face dangers to themselves on a regular basis. So I would not characterize firearms as an accessory.
So I may interject. I didn't mean to imply. I intend to say it's not necessary for functions of life, but rather that kind of previously we viewed a man on a frontier. An essential part of his being was his arm. Certainly in the same way that kind of aristocrats of old, an essential part of their character was to have a sword. But now that's no longer socially viewed as like kind of part of your being, kind of in a sense of identity. And I want to just ask about whether the identity of social context has changed jurisprudence. I understand that it is still very important for me.
I think it's particularly important when any particular group feels imperiled. So whenever there are riots and, against some particular group, those people want to be able to protect themselves and their families. And that's happened over and over again. And right now, there are a lot of Jewish people lining up to buy guns who never thought that they would ever even want to touch a gun. So it's a kind of safety valve, I think, for people the police can't be there all the time. They can't protect everybody. So people need that right to self-defense, and this is one way to get it. Go ahead, Bob.
Yes.
I think in recent years, we've seen more restrictions on like weapons modifications or accessories. What comes to mind is like the bump stock ban or the
Yeah.
ATS pistol brace rule. How does the Second Amendment jurisprudence play into that? And what historical analogs may there be for those sorts of restrictions?
Well, it's interesting. The court has just granted cert on a bump stock case. I actually wonder, if the deciding factor in that case should be in fact the Second Amendment, or should that be looked at more as really a case in administrative law? To what extent can an agency make law, and particularly criminal law, in this particular case? I've heard a lot about bump stocks. I don't actually know to what extent they do what the hype suggests, which is give you the equivalent of full automatic fire or not. But it'll be interesting to see what the court does with that. Yes.
So one issue I've seen a lot, especially coming up in Fourth Amendment context, is the police officers without a warrant go and grab people's firearms. Sometimes not even in the context of an arrest, under some special needs exception or some other carve out under the Fourth Amendment. Let's say if the Bruin test, as applied to a lot of these regulations, gives people, I guess, more ability to purchase firearms, do you think there's a danger that the law enforcement and the government will try to seize people's firearms under some other excuse, and where would that be?
I think we might see that, particularly for groups that they've long tried, police have long tried to disarm in some ways. I mean, that may very well call out for a kind of selective enforcement, or authorize a kind of selective enforcement, which is dangerous, certainly. Yes.
Has there been a struggle to kind of follow the thread from the founders' concerns about some of the 17th century religious wars in England that kind of, according to Justice Scalia, influenced their decision for including the Second Amendment, bringing that forward to today, and what you were talking about with different minority groups and protect themselves, where American government's become such a bigger part of people's lives between the founding and today, and kind of being able to draw that thread, from history and say, hey, this is still very relevant today, even though government is a much bigger fixture of people's lives.
I think we don't talk enough about the macro case for arms ownership. In other words, we talk a lot about the criminological case. Does arms ownership by the public deter or not deter crime? There's a robust debate on that. We seem to have let, to some extent, fall by the wayside the civic republic aspect of it. Do we want an armed society as something of a counterbalance to a government that may go astray? And that's perhaps too far removed from our radar screens. And I think it may be removed because we think, as President Biden seems to think on this issue, well, to overthrow the government, you need an F-16, not an M6 or an AR-15. One of the questions that we might want to ask, and we've looked to our own history for this, is the civic Republican purpose served, deterrence to government misconduct, simply by a basis to have an individual self-defense? And I think the history of the civil rights movement may have that. what happens when you have a hostile government that for political or racial reasons will not protect you? Is it important for you to be able to protect yourself so that you don't, the sheriff can oppress you simply by going fishing when the lynch mob comes? And we've forgotten that history, and perhaps we need to re-look at it. And I think when we do that, we'll see that even that civic Republican purpose, stopping a government that might go astray, is still a very important one, even with modern technology and all the other considerations that we might have.
Can I just say something? I'd like to just get back to your point that when you mentioned religion, we've seen attacks on churches and synagogues and, all over the country at different points. And one of the changes that New York State made immediately after the Bruen case was to come out with this new draconian rule. And it included for the first time that you could not have weapons in a place of religious observation unless you hired some professional. And I was involved with a law firm that was representing 3 Orthodox Jewish congregations in New York who were really worried and about this particular clause. And in looking at it, I discovered that a lot of churches and synagogues have people in the congregation who come with arms, and they know they're there, and they seat themselves in particular places in that sanctuary to protect the congregation from harm from some crazy person who's going to come in and try and cause mayhem. So I hadn't realized that, even in my own church, one of the directors was talking about the rector, and he said, I would take a bullet for that man. I mean, I think that there's worry in these congregations, and we've seen, happily not that much, but often, some wild person coming in and taking revenge. So sometimes, even though it isn't sort of generally against the government, it's protection against some person who's deranged or just vicious coming in and harming a group of people for their faith.
I wonder if we're drawing close to the end here. No, but I'm wondering if I might try and end on a different note.
A happy note.
Well, a different note at any rate. I'm wondering if the attempt to essentially read the Second Amendment out of the Constitution, or at least read any significant meaning out of the Second Amendment, has actually had an unintended consequence, which is it's made gun control, as distinct from gun prohibition, much harder to achieve. If we had, from the beginning of the national modern gun control movement in the 1960s, had a universal consensus that said the Second Amendment really means something. It sets real limits on the extent to which the government can prohibit firearms ownership. We're not going to find ways or try and find ways to circumvent that. What we instead want to do is find the measures that we can to prevent the wrong people from getting guns. And we could debate whether these should be waiting periods or this screening measure or that screening measure. We could debate those. But if we didn't have sort of a gun prohibitionist movement that says every regulation that we can get, we see as a first step on the road to ultimate prohibition. And if the courts had stepped in very early and said, prohibition is off the table, then we could have had a productive, I think, a productive debate on which screening measures are likely to work and are likely to work without harming the core right. I think we'd be further on the road to a policy of public safety with respect to firearms, had we gone in that direction, than in this sort of, well, this thing really doesn't exist and it poses no impediments to our agenda, which we frankly admit is prohibition. You know, and DC was supposed to be the poster child for that. You cannot have a gun in your home for self-defense. Okay. You know, might we have achieved if we had had a much more productive debate saying there is a right and it's subject to reasonable regulation, just as we do with the First Amendment. There's no mass movement, and believe me, the NRA is a mass movement. There's no mass movement opposing parade permits because we know the courts will ultimately vindicate our right to peaceable assembly. Would we have a mass movement opposing every conceivable kind of gun control measure if indeed the courts at the beginning had said, you can go so far, but not beyond that? So if I might end on that and then say, we have books for sale. So, if you have,
I know. Where are the books for sale? I was waiting for you. I have been, I didn't know.